Can a lawyer be prohibited from soliciting the clients of his former firm? The general rule is that restrictions on the practice of law, including any non-competition agreements, are void and unenforceable. It came as a surprise to me, therefore, that the Appellate Division in the First Department in New York had affirmed a trial court decision that let a case go to trial alleging the breach of a non-solicitation agreement signed by a former lawyer. My name is Jay McDaniel. I am the head of the Business Divorce Litigation Group at the Wiener Law Group and the chair of the Corporate and Business Law Department. We're a law firm with offices in New York and New Jersey. Please take a moment to subscribe and to like or comment on this video. It helps me to get this information to others who might find it useful. Please also take a look at my blog, www.thebusinessdivorcejournal.com, for more information on business divorce. You can also reach me directly if you need to through the blog. The case is Feiner and Levy versus Zohar. Here are the three most important holdings in the decision. First, an agreement prohibiting a former associate of a law firm from competing with his former employer within 90 miles of New York City was void and unenforceable. No surprise there. Second, at least in this case, unlike the restriction on practice, the breach of an agreement to not solicit clients of a law firm by a former associate actually may be a viable cause of action under New York law. And third, the rule of professional conduct that precludes restrictions on practice may not bar a claim against a former non-lawyer employee. In this case, the former employee who solicited clients in breach of a non-solicitation agreement, the court said, might just be held liable for that. The case involved an immigration firm, Feiner and Levy, and a former associate of the firm named Gadi Zohar. Also involved was the law firm's former office manager, Jihan Alsi, who left to work for Zohar. Now, Zohar had executed an employment agreement that contained a non-compete and confidentiality and non-solicitation provisions. The non-compete imposed a 3-year bar on soliciting clients of the firm and a bar from competition with the firm within 90 miles of New York City. It also had a prohibition on advertising in Hebrew. After Zohar left and he and Alsi solicited the firm's clients, Feiner and Levy filed a lawsuit. Zohar then moved for summary judgment to dismiss the case, arguing that the agreement was unenforceable under Attorney Rule of Professional Conduct 5.1. Now, this rule of conduct prohibits a lawyer or a law firm from participating in any contract restraining an attorney's practice of law. It makes non-competes essentially unenforceable against lawyers. And most states and most courts give the rule extremely broad interpretation. They are loath to enforce any contractual provision that appears to limit the ability of a lawyer to practice after leaving a law firm. The rationale behind it is that clients are not assets or property of the firm. They're free to follow and go with any lawyer that they choose to. In any event, the Appellate Division in this case affirmed that the geographic restriction was, in fact, unenforceable, but the court was less clear with the non-solicitation provisions. Here's what the appellate court said. The defendant's submissions in the case had failed to establish that the non-solicitation clause was unenforceable as an undue restriction on Zohar's ability to practice law, or that Zohar did not, in fact, solicit plaintiff's clients through Asli in violation of the employment agreement, which the court said would be actionable. The court then looked at whether the former office manager might see protection under the Attorney Rule of Professional Conduct that Zohar argued protected him. The court held that the ethics rule did not protect Asli as a non-attorney acting on Zohar's behalf from a claim that she had breached the confidentiality agreement that she had executed. The First Department relied on 2 cases involving attorney behavior that was overreaching and troublesome. The first of these is Grauber, Mullen, Dannett, and Horowitz versus Moskowitz. That's a 1995 decision of the New York Court of Appeals. Court there held that a departing partner who had surreptitiously solicited clients before informing the firm of its intention to resign could be held liable. The court held that although restrictions on practice are void, a law firm partner is still liable for breaches of fiduciary duty that occur before he leaves. Soliciting business or clients for a new business venture while still employed by the old is a definite breach of fiduciary duty. The second opinion the court relied on was Feldman versus Minors, and this was a 1997 opinion of the First Department, holding that an agreement made in settlement of a matter to not assist future plaintiffs against a particular defendant was actually enforceable, and that it had been violated by the defendant's, in that case, attorney solicitation of potential plaintiffs against the same party. So what's the takeaway from the decision involving Zohar? Well, first, it appears that the appellate court views differently non-solicitation provisions than it views agreements not to compete. One of the issues that did not come up in this case is whether a law firm can prohibit a lawyer from soliciting the client on matters that he or she handled directly. The professional conduct rules indicated that that question would have to be resolved differently because clients have a right to know about changes in the person responsible for their matter, and they have a right to follow that lawyer if they choose to when the lawyer leaves the firm. Second, a non-lawyer civilian is not going to get the same exemption from liability, even if it applies, as does a lawyer. And there are some decisions in other jurisdictions that have tended to follow this view. So, when a lawyer has executed an agreement not to solicit and uses a non-lawyer to make the solicitations, both of them may face liability. And the non-lawyer is likely to have a difficult time trying to get the court to use the professional rule as an insulation against the non-lawyer's own liability. Thanks for listening, and don't forget to subscribe to our YouTube channel or to like and comment on this video. Thanks again.